Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if a party to a CCMA disputes delivers an objection to CONOP late in terms of the CCMA rules. Now, as you are aware, the processes at the CCMA in dealing with disputes referred by parties are typically that of conciliation and arbitration. Certain disputes are set down as CONOP, meaning that on the set down date, the matter will first be conciliated, and if conciliation fails, the matter will immediately proceed to arbitration on the same day. Rule 17 of the CCMA Rules provides that a party to a dispute may object to the arbitration commencing immediately after the conciliation, and the rule further provides that such an objection must be filed at least 7 days prior to the scheduled date. But what happens should the objection be lodged less than 7 days before the CONOP process? Now, a judgment on this question was handed down on 3 Feb 2023 in the matter of Valinor trading as King's Castle versus De Jager and others. Now, in this matter, the Labour Court had to determine whether a commissioner is empowered to ignore an objection purely on the basis that it was not raised within the time constraints, being within at least 7 days before the enrolment date, as provided for in the CCMA rules. Now, in this matter, an unfair dismissal dispute was referred to the CCMA. The dispute was set down for CONOP on 10 September 2018. The respondent filed an objection to immediate commencement of the arbitration by 3 days before the scheduled date, so they were late. The employer party did not attend on 10 September, and as a result, the conciliation was unsuccessful. Now, due to the fact that the objection had not been sent by the employer within the 7-day period required by the CCMA rules, the CCMA proceeded with commencement of arbitration in the absence of the employer and issued a default arbitration award in favor of the employee. The employer applied twice to have the default award rescinded, but both applications were dismissed. So the employer launched an application to review and set aside both rulings made by the CCMA. So what did the Labour Court say? The Labour Court firstly held that where a party has objected in terms of Section 191 of the LRA, irrespective of the fact that the objection is late, a commissioner is not empowered to proceed with the arbitration or to ignore the objection. The court said that should a commissioner ignore the objection and proceed, the decision that follows is a nullity or is void. The court said that the relevant LRA section 191 does not prescribe a time period within which to object, and accordingly the rules of the CCMA cannot prescribe a time period. In this regard, a commissioner should not be restricted to complying with the time periods prescribed in the CCMA rules and has a discretion to condone any failure to comply with the time periods. The court further held that the CCMA rules do not prescribe that if a notice of objection is received late, that the objection is null and void. The court therefore held that a late objection to the commencement of arbitration proceedings is still effective, and a commissioner cannot ignore and decide to proceed to commence with arbitration proceedings merely because a party to the proceedings has objected outside of the prescribed period. Employers and employees, you should however take note of a recent directive that was issued by the CCMA in response to the matter that we have just discussed. Now, in this directive, the CCMA informed its commissioners of the CCMA's decision to file an application for leave to appeal the judgment that we have discussed. The CCMA states in the directive that the effect of the application for leave to appeal is that the operation of the judgment is suspended pending the outcome of the application for leave to appeal. Therefore, at least according to the CCMA, Rule 17 of the CCMA rules remain in full force. At this point, we don't have any further details on whether leave to appeal has been granted, but we will definitely keep you informed. So, although the case states that a late objection to the commencement of arbitration proceedings is still effective, it does appear that the operation of the judgment is currently suspended because there's been an application for leave to appeal, and the suspension will be for the period until there's an outcome on the application for leave to appeal. So therefore, in the event that you want to object to CONOP, we still recommend that same is done within the prescribed time frame so as to avoid any surprises. Ladies and gentlemen, that brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media or email us at info@masconsulting.co.za. If you are interested in staying up to date with the latest news and insights on employment law, be sure to subscribe to our YouTube channel. Thanks again for tuning in. I will see you next time. Bye-bye.